300, 400, 500 pages. Now it is online, everything is online, and you can get any information you want, number of judges, salary of judges, prosecutors, numbers of prosecutors, and so on. Notaries, lawyers, and so on. So everything pertaining to justice you find in this biannual report. Then there is a certain group which deals with the questions related to the time frames, reasonable time frame. Actually, this page has been constituted and created on the basis of the fundamental text which is at the of the Council of Europe, which is to say the European Convention for the Protection of Human Rights, whose Article 6 says that anyone has the right to a judgment from a tribunal which is impartial and independent, and these questions are dealt with by the Consultative Council of European Judges, of course, and it has to be done in a reasonable time frame. And that is the reason why Council of Europe and now the page have deal with the questions pertaining to the agency of justice. Then we have the group which is called QUAL, which deals with questions pertaining to quality of justice. And finally, the Cyber Just, which is the group which deals with artificial intelligence and IT in the administration of justice. So the CEPEJ started to take an interest in artificial intelligence years ago when it studied deeply and approved in the year 2018 the famous European Ethical Charter on the Use of Artificial Intelligence in Judicial Systems, which is the first document of this kind in Europe and in the whole world. There are some principles which are stated in this important document. You see them on the screen: respect for fundamental rights, non-discrimination, because you know very well that I can bring about situations of discriminations, maybe based on ethical origin and so on. Quality and security of the AI systems, transparency, impartiality, and fairness, and finally, something which has been underlined by the people, presenters who preceded me today, AI must stay under control of human beings. And talking about justice, AI used by judges must stay under the control of a judge, of a human person called the judge. So after this, the CEPEJ understood that it was important, of course, to proclaim general principles enshrined in the Charter, but it was also important to have a tool to assess concretely the situations in which we have maybe new AI experiments, new AI systems, new AI programs. How can they be, should they be assessed whether or not in compliance with the principles stated by the Charter, the Ethical Charter? So last year, in December 2023, the General Assembly, the Plenary Assembly of CEPEJ approved an assessment tool, a document which is called Assessment Tool, whose intention is to help judicial decision makers implement the principles of the European Ethical Charter. Of course, in my written report, you have all the links to the pages of the websites. You find these documents in their entirety, and also some comments about them. Also, talking about CEPEJ and Council of Europe, we must mention this body which was created in the year 2021 under the name of European Cyber Justice Network, ECN, whose tasks are the tasks that you see here: to exchange information on good practices concerning, of course, AI, to consult on matters falling within the scope of the mandate, to provide up-to-date background and statistical information on the situation in the different, now 46 member states of the Council of Europe, to initiate proposals for new tools, to disseminate information, to organize training on questions related to AI and compliance with the ethical charter, support local initiatives, and provide a multilateral cooperation. In this framework, I would like to quote here, to make a reference to this instrument that we have available within the website of the CEPEJ, which is to say the Resource Center on Cyber Justice and Artificial Intelligence. You see that the page is organized a little bit like those of you who know this website of the Council of Europe and of CEPEJ will be surely familiar. You have a map, and then you choose a country, for instance, France, you click on it, and you have a list of resources of IT and in particular AI related to that country. This work is a huge work, of course, which is behind this instrument that we see now on the screen. And it's a work of collecting information from single countries. You see that you have, now it takes a little bit to show on the screen, but there is also India, which of course is not a member state of the Council of Europe, but also countries like Brazil or Argentina, United States and Canada, that provided information on IT and AI. What we can do, for instance, if we choose a country, I was referring to France, if I manage to have this work, because it's a little bit slow now. You get a list down of the initiatives which have been recensed by this data. Actually is a huge database. We collect the information that comes from the relevant countries, which is furnished, given by the countries, and then there is a link, and the link sends to the information concerning the different initiatives of that given country in the field of IT and AI. Sometimes the information is only available in a foreign language, a language which is not English, but the important thing is that you have an information in English generally presenting the initiative, and then you have the contact details, and if you want to deepen your inquiry, you may contact directly the institution, the public administration, and so on, which developed a given initiative. Well, as a working group Saturn, which I have the honor to coordinate, and we have as a member also Sabine Matejka, Vice President of EIJ, we are working on this particular aspect, which is to say, what are the effects under the viewpoint of efficiency? So the question is, does the use of AI system improve or not improve the efficiency of justice? In order to reply to this question, we have to try to single out, first of all, what are the fields of interest of artificial intelligence, in order to see whether or not they may improve the efficiency of justice in given fields. We have a list here which is not exhaustive, but it has already many references, like the field of document search, review, and large-scale discovery, online dispute resolution, prediction, also so-called predictive AI, decision support, anonymization, e-filing, triage, allocation and workflow automation, transcription and translation, information and assistance services. This list was made on the basis of the examination of the database that I showed you before, from which we get the idea that, for instance, we have 10 plus 5 is 15 initiatives concerning document search, only one concerning automatic online dispute resolution, one concerning prediction of litigation outcomes, but it refers to prosecutors, and so on. But of course, it is a work which is in progress, and every day we have new data or new information. What is important is that a recommendation that we can give to judges, not anything that is AI applied to justice refers directly to the activity of the judge. Let me cite, for instance, the question of anonymization. Anonymization does not, theoretically speaking, directly involve the activity of the judge. The judge ends his or her work by signing the judgment, and that's all. Then the anonymization is a question that comes before the persons or the publishers, the editors who want to publish a given judgment, and they have the problem to respect the privacy of the people involved in the case. The same is true for the prediction of litigation outcomes. It is not to the judge to transform himself or herself in a sort of a Sibilla Cumana and telling the future what happens. The judge has strictly to say nothing about his or her case. Only with the final judgment, he or she will speak up and say, this is the final solution. It is useful, of course, for lawyers, for other people involved in the administration of justice, let us think, to mediators, for instance, and to the general public, but not specifically to the judge. And also the online dispute resolution is something which is parallel or sometimes also in competition with the administration of justice made by the judges. There are, on the contrary, other fields in which the use of AI could be really very important. I always, in the field of e-filing, cite the concrete problem which arises in my country, for instance, from the use of what we call processo civile telematico, which is to say a system of e-filing which puts in connection the lawyers and the judge and the clerks, of course, and vice versa, which has very good aspects, but also some negative aspects. I have not the time, of course, to go into details, but in a nutshell, the negative aspects are that the judge is involved in each and any event concerning the electronic file he or she has, okay? We are talking about civil cases for the moment. So it means that each and any event that concerns a file of a given judge will be notified to the judge. The judge sees on his screen that something new has happened in the case he or she is dealing with. Then he has to go into the file, open the file, and discover what? Discover that, for instance, the lawyer has paid the fees. Okay, very good, very interesting for the state, maybe, but it has nothing to do with the judge. Or to discover that the file has traveled from the clerk's office to the tax office and back from the tax office to the clerk's office. Very interesting, but nothing to do with the activity of the judge. So we need an activity of triage. By the way, on the basis of my experience, I've been using this system for almost 10 years, and the final result is that about 30% of this information concerns directly the judge. 70% concerns the clerks. So we should have a sort of triage, make a distinction between the information that goes to the judge and obliges him, her to open the file, to lose the time to open the file and to read and to understand whether or not it is relevant for the case and for him, for his activity. And the information that has to go directly to the clerk's office and has nothing to do with the judge. So a system of AI or artificial intelligence could be, in my opinion, set up in order to make this distinction with the final result of having the judge have a consistent time advantage because he's not losing 60 or 70% of his time in opening files which are not of interest for him. So now very quickly, the hard law profile. The Council of Europe, so far I have been talking about questions which deal with soft law, of course. The Charter is not an international convention. It's not binding on the states. It's not binding on people, on judges. passing, on the contrary, to the side of hard law profile, you know maybe that on the 17th of May of this year, the Committee of Ministers of Europe adopted this framework convention on artificial intelligence, AI, and human rights, democracy, and the rule of law. As you can understand, of course, the scope of this international framework convention of the Council of Europe is much larger than the activity of the judge. But of course, the activity of the judge is involved, is included in this scope. And something which is quite related to this initiative, to this convention, is what they call the Hudiria methodology. Now, we have to get familiar with the acronyms. Impact assessment of AI systems on human rights, democracy, and the rule of law, short, Hudiria. It is a methodology to understand whether or not a new system or old system or artificial intelligence is compliant or not. This time, not with the ethical charter, but with the document which, if it is approved, signed, and then taken into the different legal orders of the states member of the Council of Europe, becomes relevant for the judges and for anyone. So, a few words before closing about the European Union. Of course, we are no longer in the field of Council of Europe. We are in the field of European Union. You know that European Union approved an Artificial Intelligence Act recently, which will enter into force in July 2026. It will be a regulation binding on all. So we are not, of course, any longer in the field of soft law, but in the field of hard law. So the regulation will be binding on all EU member states. And here also there is something similar to Huderia, but it is called in a different way, another acronym we will get too familiar with, Fundamental Rights Impact Assessment, FRIA or FRIA, I don't know how it's pronounced in English. FRIA or FRIA takes care of the fact that AI systems can be innocent, so to say, related to activities which do not bring about risk, but they can be also within systems that bring about some risks or high risks, as they are called in this act. So the fields which are supposed to deal with high-risk situation are, of course, administration of justice and law enforcement. So the activity of the judge is in this situation. And here is, as an example, the criteria that are used to say whether or not an AI system can be considered of high risk or not. So we must think to AI systems intended to be used as polygraphs, or evaluate the reliability of evidence, assessing the risk of a natural person offending or reoffending. You know, the American case is concerned to ethnical origin of offenders, for the profiling of natural persons, to assist the judicial authority and interpreting facts. So FRIA or FRIA is a systematic examination of potential risks, as I said, and according to the above-mentioned new act, prior to developing a high-risk AI system, the deployers will have to perform this assessment. The assessment is quite complex because it is a description of the processes and a description of the period of time within which and the frequency this high-risk AI system is intended to be used, the categories of natural persons and groups likely to be affected by this high-risk activity, the specific risk of harm likely to have an impact on the categories of natural persons, a description of the implementation of human oversight measures, the measures to be taken in the case of the materialization. So what happens if those risks materialize? What shall be done as far as the IA system is concerned? So once the assessment has been performed, the deployer shall notify to a new authority, a market surveillance authority is called like this, of these its results. And so the AI office shall develop a template for a questionnaire, including through an automated tool, to facilitate the deployers in complying with their obligation in a simplified manner. So all this complex system is supposed to come into force as of July 2026. So we still, thanks God, we still have some time to get familiar with this novelty. Okay, thank you for your patience and for your attention.
Thank you, Giacomo. Now I'd like to call Nazim, our colleague Nazim. He has an announcement on behalf of JOASA about our agenda before we pass to the conclusions of this conference. Hi, Nazim. You have the floor. Going to have the debate before? Because she said no, we don't have debate.
Okay. Still good morning. Just an announcement I want to do first of all with regard to the excursion. I know that there are many people of the Muslim faith that are here. So on the excursion, we will be going to the wine route. But as an alternative to those that do not want to go to the wine route, we will visit a few holy sites, as we can call them. In here they refer to them as kramats, where the Muslim delegation would be going to. I just need all of them who wants to go and visit all these heritage sites of great Muslim leaders and pioneers who basically started off Islam in this region. We will visit those sites. If they can give their names to Romy and Vanya outside, so that we can determine how many buses we need to deviate. We will ultimately come back to the wine farms, because we need to move as a unit again to our final destination, which is at Moyo, Kirstenbosch area. Thank you. I just want to, just before we leave, I just want to introduce some of my local organizing committee members. One has already left. I wanted to save that for tomorrow, but as they are going, I thought it would probably be appropriate to do it now. The arrangement of this conference wasn't an easy one. We had lots of hurdles. As you can see, one is our security hurdles, as well as cohesion between our Department of Justice and the Judicial Officers Association. We are independent of the administrative part, but yeah, we need them to facilitate things. I heard our special rapporteur also talking yesterday about intervention on how she needed to be extended an invitation from probably the government to initiate. And I still want to discuss that with her, because when you have an issue as the judiciary with the actual government, to get them to get that extension for the invitation would create an issue. So that's probably something which we can discuss later. But I just want to call on our members. Some of them don't really want to come forward, but I hope they would. I see JP Musi is already putting his head down, but it's not going to help. So let me call up the members as they are. Mr. Mazwi is the Vice President of JOASA. If you can just come forward as I call your names, and I hope I'm not going to miss all of you. Ruben Jankis, JP Musi, I also need the engine. You know, these are men I'm calling, but it's normally the women that does all the hard work and the grafting. We have Vanya Karth from UCT. She can't be absent, she's outside. Yes, please. John, I'm going to call you up now. We also have Carmen Parks, who you have seen outside here, one of our magistrates, regional court magistrate, who has been working tirelessly at the desk. I'll call them in now. We also have Romy Keys, who I think you're all familiar with the emails, as well as Felicia. And it's always those that work very hard that doesn't want recognition and accreditation. But knowing what we've gone through for the last 10 months, I think really they should come forward, and we should acknowledge the hard work and the many hours they sacrificed to make this conference a success. I'm being a bit presumptuous by saying a success. You'll have to tell me that later. Okay, so while we're waiting on that, I think I'm just going to call some of my national executive members forward, if they are here. Chris Abrams. Chris has been very helpful with regard to the transporting people to and from the airport, because we only had transport for our arrangement was for the 18th. Lots of delegates came the 16th before that, and after on the 19th. So if all those NEC members can come forward, Tabogo, I can see. Ruben, where is Ruben Jankis? I saw him here earlier. I know that women always shy away from coming to the front. I have never known that men does that. Where is our National Secretary, Bettina? So if all those NEC members can just come forward. Sandile, where are you? I saw you popping your head in. Thank you. As you can see, this is the engine and the heart of the local organizing committee, all women. I think I did my fair share also, so I could stand next to them. Our president is just in a meeting, so he cannot be here at this moment. If there's any NEC meeting, a member that's still sitting, please come forward. And as I say, any Muslim that wants to go to the kramats and so on, you can give your name to Felicia. This is Felicia who's been sending all the emails. So you... And I think they became aware of the different time zones, so you'll get the email at 2 o'clock in the morning, our time, but it's probably just about 8 o'clock somewhere else. So these are all the things we worked with, but with all these challenges and without naming them, I must thank them for pushing through and making the conference happen. Thank you very much. Okay. Just one final thing on the wine tasting tomorrow. There is also a list. Oh, Walter, were you going to do that? Okay, thank you.
Leave at 9 or 12?
No, we're going to leave at 12.
12?
Yes. That was also an issue with regard to the security, which we had to change to accommodate security risks. And so, although it's no longer in place now, but it was an issue which we had to curtail the outing, because our hours was now between 12 in the morning or in the afternoon until probably about 10 at night or 11. Depends how good the party goes at Moyo. No, sorry, not tomorrow, on Tuesday, the 22nd.
It's the excursion. Also, yeah. The general excursion, we will leave here at 12, not at 9. Okay? Everybody understood that?
And everybody that wants to do the tasting, just make sure that you write your name down, and there's a levy that they're charging. It's 100 Rand, I think.
100, yeah.
Yeah.
So,
thank
everybody
you
understood? On Tuesday, we'll leave to the general excursion at 12, not at 9 a.m. Okay, at 12. Not tomorrow, but Tuesday. Tuesday. Yeah. Tomorrow we will still have the Central Council at 9. But the excursion on Tuesday will start at 12. Any doubt about that? So tomorrow at 9, Central Council, as always. But on Tuesday, the general excursion won't leave from here at 9, but at 12. Yeah? Thank you. Well, my mistake, I had been informed that we wouldn't have the debate, but we do have it. So let's start with the debate. I'd like to know if anyone have questions to our speakers, if the speakers would say something else about the expositions. Who wants to start? Do you have microphones for the audience? Yeah? Here, microphones. Do you have questions? Who have questions for the speakers? Here, just a moment, the micro. Here, please, Mad. Canada.
Hi, it's Bill Goodrich from Canada. One of the questions I had relates to the first presentation this morning when we had a look at these potential software packages that offer AI services. Some of these are, I understand, very expensive. The ones that the large law firms are using are in Canadian, US dollars, hundreds of thousands of dollars. So, you know, the idea of judges getting the administrative branch of government to fund these aids or partners, if that's where we're going in the future, you're like, how is that going to happen? And is it happening anywhere already? And I'm not sure, but I think Microsoft Pilot might be free and ChatGPT might be, or low cost, but the lower the cost, the less reliable and less control we have over the data. So I wouldn't mind getting comments from the speakers, it doesn't have to be the first speaker, on how are these packages available to us? Can they be available if they're this high-end cost? And the better the quality, the higher the cost. In other words, if we're going to eliminate bias and the risks from the software, we're going to be paying, and someone has to monitor. So how's that going to happen?
I could answer that. You are right on. Currently, within the Ninth Circuit, we have a working group, and the working group is piloting, just a few judges are piloting various programs and evaluating the license fees versus the utility of the costs. As I said, because our database is Westlaw, it's not surprising that Westlaw has provided to us a tool that's at very low cost, and it's pretty reliable. But these issues will have to be decided. I think a lot of the law firms are going in one direction, and some are developing their own programs. And the judiciary and the funders, one of the conclusions that we'll talk about tomorrow at the study commission is that if we're going to use AI, there has to be adequate funding and also adequate training. Your question is very relevant.
Thank you. Anyone else?
Thank you for these very valuable presentations. A question that I have has to do with, of course, judicial independence. I wonder if there are good practices on disclosures that you might require to assess either the algorithm or other elements of an AI system in order to determine whether you're able to protect judicial independence. So have courts adopted certain kinds of rules? And if so, how are things going? Are companies handing over disclosure of information they might otherwise see as proprietary?
4 judges in the federal court system issued specific guidelines in response to the fake ChatGPT brief. However, many people that are looking at those guidelines say it's overbroad. In our study commission, we had major arguments about what is AI. Does it encompass everything? Is it only the generative AI? Are these requirements to disclose overbroad? Do they implicate the lawyer's work product on some things like e-discovery that they may not want to disclose their specific plans and programs that they use? So those are things that are being looked at across the board. And then in general, at least in our federal court, we have existing rules already that would be able to sanction lawyers if they're, or parties if there's abuse.
But what about disclosure to you from a company so you can assess the tool?
Oh, I see. You're saying on piloting. On piloting. I think that's a case-by-case situation. Some companies are marketing these aggressively. Some we've seen problems with the tools, and some we've seen these really aren't very helpful either. But so far, I don't think that there's a lot of disclosure by the companies.
I might just jump in. Jump in first to the first question about cost. I think you'll see that cost here will follow as it has previously with hardware and software. It starts high, competition comes in, and I think we'll start to see really very much of a price drop as a result of competition over time. The question you raise is a very interesting one, but a complicated one, because I think in the EU Act, they talk about transparency and in disclosure. How is that going to happen? And when I've talked to people about that, they said that's very hard. When you say, please disclose the databases you're looking at, you know, you're looking at billions of gigabytes of data. So it's very hard to have transparency and disclosure. So I think that's more of an illusory principle rather than something practical, and it'll have to just be used and tested, because, you know, companies are saying, well, what do you want us to disclose? What are you talking about? And I think that is the practical problem. So I think you'll just have to assume that once courts start using these, they need to use them in a thoughtful way, and you need to double check. And so I think that the determination of whether there's bias or discrimination or problems or hallucinations, that's going to come down to the user, not to the company, because I don't think it's going to happen.
Can I just chime in here?
Green. Here's,
Can we hear each other? No? Okay, great. Thank you. Let me just chime in here with after the excellent answers from the honorable judges sitting next to me. Yes, and I think in terms of companies disclosing their algorithms and how they have arrived at the expert systems that they have developed, we are already seeing in other sectors, such as credit lending and so on, that this is a very difficult, if not impossible, because of IPR issues. However, there is a huge pushback in that regard, at least to set some guidelines and frameworks to allow some form of transparency there. I would like to turn it around and put the ball back in the court of the judges here. However, I think transparency and disclosure, there is a minimum and basic level of transparency disclosure that we need to consider for the actors in the justice system, including the judges. So at the very basic level, has the judge used a supportive AI solution to arrive at a decision in the first place? In the same way that we would, some jurisdictions are now requiring of attorneys and counsel presenting before court to disclose if they have used AI solutions. And I think to bring it back to the preface of your question around judicial independence, we know that part of judicial independence is the judge currently is not required to disclose how they have written the judgment and what sort of research they have done. But do we need, in this day and age of misinformation and fake information and so on, to have us actually judges disclose what kind of tools they have used to arrive at the decision? So it's not really an answer, but I'm putting it back to the floor. There is that question as well. And that's a minimum basic level of transparency that we also need to consider as judges. Thank you. But with respect to that, and it's a perfectly legitimate point, but let's take it one step further. Turn it back to the judges if you wish, fine. But the judges have to turn it back to the lawyers. What are you presenting to us, and what tools have you given us? When I review a brief, I review research that has been done by the advocates to the case. So would I also be obligated to go back beyond the presentation of the briefs, et cetera, that have been submitted to me? Where does the obligation end, if you will? Where does it start and where does it stop? Thank you.
Mm-hmm. I think one critical part is that one of our conclusions from the study commission is that lawyers are responsible for submitting accurate information to the court. When they sign their name, that means that it's a representation, that it's accurate. And if it is not, the court can take appropriate actions to deal with that. The flip side about the judges disclosing everything is so contrary to our system of justice. So that I understand the two-way street, but I have problems conceptualizing that.
Well, I think one of the risks for judges is going beyond the record and doing independent research that is not related to the facts that are in the record or that occurred at the trial. And we already have that issue with the internet. So some judges will use it to understand a technical term. And the question is, well, how far can you go? And at what point do you need to disclose to the parties? Because otherwise, the judge is acting really as a fact finder, and it may depend on the system as to whether that's permitted, but by and large, I think that the bigger risk is the judge undertaking independent research beyond the record and the parties not knowing that, and it may inform the decision, and you may not see it directly, but it might indirectly be infused into that. So I think that's a risk where judges need to think about, well, what are your ethical rules that might prohibit that?
Hello. Mr. Mohammed Alawi Morani from the Moroccan delegation.
Okay.
First of all, we would thank you for proposing the discussion of this subject, that is the AI and the justice. And we already began to work with the system in Morocco for like 10 years ago. And we think that the AI is very important for leading and improving the judicial system. However, the AI is developing in a light speed, and the justice system is really slow to catch up with. The dark web and the manipulation is very jeopardizing the whole system. We cannot really trust the AI in our judgments, first of all, because we have to put some procedures and to try it in some limited areas in our justice, in our system, and then try it for like one decade almost, just to see if it's gonna work or not, or it's not affecting negatively the work of the judge. Secondly, I think that the judge must remain the main tool in the whole judicial system. The AI must be just a supportive tool, but not the whole thing, not the whole thing. I would like to thank you for this, for the subject, but also I hope that the International Association of Judges make us some kind of a model that must be proposed to all delegations to work with in their own systems, so we can begin, but with no risks, because this has to do with people's and citizens' rights, liberties, so we cannot damage their life for trying something that we're not sure about, especially that the AI in the world is really a risky field to get into. And the whole government cannot catch up with the dark webs and the manipulations that might get inside the whole system, and maybe like making it fail at all. We thank you if you want to give us, all of us, some models during the next years to work on it and to get a good experience from you. And thank you very much.
Thank you. Well, thank you very much for your contributions. It's time already now to give the floor to our next speaker. She's Ms. Maria Badeva. She's Executive Director of African League of the Faculty of Law of the University of Cape Town. Ms. Badeva, you have the floor.
Thank you so much. And I think I have the easiest job today to just summarize, hopefully, this panel and give you some food for thought and discussion over lunch and the subsequent days. But although that was my brief, I went outside of scope. So I will just put a couple of points forward that I didn't hear in the panel this morning, in addition to the presentation that we have here. Let's start from the beginning. And first, maybe a short introduction. I was introduced as the Executive Director of the African League. African League and Laws.Africa, the two logos that you see on that presentation there, are organizations based at the University of Cape Town that work at the moment with over 17 judiciaries in Africa. And we work on perhaps in the context of this panel, a very simple problem, which is to digitize court judgments, in addition to everything else, and to digitize court judgments and present them to judges and the legal sectors for legal research. And we've been doing this for over 15 years, to the extent that we now offer full portals where judges who otherwise would not have research platforms would be able to do so in their jurisdictions that are usually underserviced. But in the course of this work, we encountered the problems that judiciaries in Africa in particular face in terms of use of technology, and more recently in the past 2 years since the explosion of AI, of some of the questions that they have regarding the use of AI in their jurisdictions. And perhaps a little bit disappointed after the panel this morning is we didn't hear a lot about the context of our countries, of African countries, and how we are battling with some of the issues that are common to all of us. And in addition to, I believe it was Morocco, the last intervention that we just had, what I was thinking throughout the morning was it would be really wonderful if the IAJ can actually continue this initiative of the public conference this morning and have a direct program that actually ensures representativity even from developing countries so that they get exposure to this issue as well as they can contribute and learn from some of the practical solutions that we've seen talked about this morning from the developing world. So this is outside of the scope of my notes. Let me continue on to the conclusions. And it really has been quite an enlightening session this morning. And as we conclude this panel on AI and the judiciaries, it's crucial to synthesize our discussions and come up with some actionable insights for judges worldwide. A resounding theme across our conversation has been, I think, the need to embrace AI, not as a replacement for human judgment, but as a powerful tool for augmenting judicial processes. And indeed, when I speak to judges in the course of my work, I think everyone is excited about AI. The first thing that they ask is, when are we going to get robot judges? And that is nowhere, I don't think that this is nowhere near, in the near future, happening. The allure of AI lies in its potential really to streamline administrative tasks. And I think that this is extensively being used across the legal sector, and it is making its way through judiciaries as well. The map that was presented earlier on by Giacomo presented the EU and India, and we heard from North America as well. In Africa, AI solutions are making their way into courtrooms as well, enhancing access to justice, particularly around translation and transcription software, as well as facilitating other administrative functions, such as producing judicial analytics that allow the judiciary to find hotspots of problematic areas within the administration of justice within their jurisdictions. They already promote greater consistency and transparency in decision-making. So imagine a world where AI assists with legal research, enabling judges to sift through vast amounts of information efficiently and perhaps uncover precedent they might have otherwise missed. That world actually exists. It exists primarily in the developed world. We are still struggling with that in some of the developing countries that I personally operate in. If you want to picture an AI-powered tools helping to translate legal documents, you don't have to picture that. That is the reality. Breaking down language barriers and ensuring that all parties clearly understand their rights and obligations. We heard this morning about chatbots being deployed in the judiciaries. I know of impending cooperation between the judiciary of Canada and the judiciary of Tanzania around assisting the judiciary in Tanzania to deploy such a chatbot on the judicial website. So these are reality. We are bringing the law closer to the people with the assistance of artificial intelligence. The research highlights these possibilities, suggesting that AI can indeed be a force for good in our justice system. However, and this is what we heard a lot of this morning, there are challenges and some ethical consideration. This optimism must be tempered with a healthy dose of caution. And we heard also back from the audience today, there is that caution exercise. AI is not a panacea. It comes with its own set of challenges and ethical consideration. The sources consistently emphasize the importance of human oversight in all AI applications. So the key phrase here is humans must be in the loop. Judges must remain firmly in control, critically evaluating any outputs generated by AI systems and ensuring that those outputs align with legal principles and ethical standards. And that responsibility sits within the judiciaries. It doesn't sit within any other oversight body, as we are currently seeing developments in the AI policy space of generally governments trying to regulate that space. A human-in-the-loop approach is non-negotiable, safeguarding accountability and maintaining public trust in the administration of justice. When I put these slides together, I didn't realize that there would be quite a lot of talk around judicial independence, but I think this is a core issue that we need to consider on a policy level, even for some of the developing countries that are still at the very beginning of the AI journey. And really with coming up with policies that ensure that judicial independence is preserved. I know on an African Union level, judicial independence is currently coming up on the radar. There will be some resolutions coming in the next few weeks, in fact, out of some of the human rights organs of the African Union. It's very much on our agenda. And the fact is, in our developing countries' context, judicial independence is usually treated under a different lens. And we very rarely think about how technology can impact on judicial independence. I think that there is a lot more that can be written on the intersection, or rather can be researched and written and produced in terms of policy on the intersection of technology, law, and judicial independence. So I've called out there several concerns. The first is the shift in decision-making power. And I think that this is particularly relevant when we discuss large language models. So if I go back to Mr. Bierwinkel's presentation this morning, largely we are looking at large language models, which is where we see the hallucination happening. And we have also the machine learning and sort of little bit older school technology and AI systems. So particularly when we speak about large language models, who is doing the decision really there? As AI systems become more sophisticated, there is a real risk that they could encroach on the judge's core function of making decisions based on legal reasoning, facts, and principles of justice. If judges become over-reliant on AI-generated outputs without critical evaluation, the perception could arise that AI is driving decisions rather than assisting judges in their deliberations. This could erode public confidence in the judiciary as an independent and important arbiter of justice. Second issue that we need to think under the banner of judicial independence is the influence of external actors. And I won't go into great detail. It was called out just now. Are private companies developing AI solutions and controlling the algorithms that fuel our AI assistance as we work as judges? Are they in some way influencing the outcomes of cases, particularly if we do not have access to the training data that was used in putting together that AI solution, or we don't know really what rules were used in building that software algorithm. We also, and this is something that didn't come up because we didn't hear from any of, I think in the debate, we didn't hear from judges from the African context. All of these AI solutions that we heard in the debate, heard of in the presentations, in the debate today, that currently exist are developed in the US, Canada, United Kingdom, Europe, and so on. They are trained on data from common law jurisdictions, yes, which many African countries share, but still on data case law that was produced in these countries. So really the question then becomes, what is the influence of other legal systems on the judges on the African continent? And here I speak with my hat of someone who presumably would represent that development point of view. So we need to think, as we adopt solutions from foreign jurisdictions or developed by commercial companies elsewhere, about the effect of these expert systems having on the jurisprudence, the development of the law in our own legal system. And this is not an old problem, by the way. It's in a similar way in the paper world, when we borrow law reports from the Canadian Supreme Court or from the English courts, and we use them in our African jurisdictions and incorporate that case law. In the same way, we are not contextually developing our own legal system. Third point there is the erosion of public trust, and that was touched upon in various contexts in the presentations this morning. We really need to worry about that. The perception of the robot judge, Judge Dredd, being the one dispensing justice in the court system, particularly as AI in general is getting some negative press out there with the people. We need to, as judiciaries, have very transparent way of communicating how AI is being implemented into our courts to manage the public perception and heighten public trust in the legitimacy and fairness of the judicial process. I think this is imperative, and it's a policy that we can implement even before we implement AI. Perpetuation of bias. Again, a lot was said this morning about bias. I would like to tie it again to development context. We know AI models are susceptible to inheriting bias from their training data. If AI systems are trained on data sets that reflect existing biases or inequalities, they could perpetuate and even amplify those biases in judicial decision-making. This could lead to unfair or unjust outcomes, undermining the principle of equal justice. Again, if we have AI systems developed elsewhere and not in any of the African countries that are represented here, think about introduction of bias that is not even relevant to our societal context. We need to think about lack of transparency and explainability. Again, the term, and I didn't hear it, it's actually called the black box, and it's quite, that terminology is being used around all sorts of expert systems that are being used to help with decision making across various industries. Black boxes are very much relevant in the legal domain as well. where decision-making processes are opaque and difficult to understand. And this is fundamentally at odds with the principles of fair and transparent justice and fair trial. So when we deploy AI solutions in our judiciaries, and I hope this is a takeaway that you would take with you, we need to ensure that all processes in terms of implementing and what data the system is being trained on need to be transparent and explainable in terms of how we use it within the judiciary. There is a need for a cautious and principled approach to AI integration, particularly when it comes to safeguarding judicial independence, emphasizing human oversight, promoting transparency and explainability, and addressing bias, crucial for ensuring that AI remains a tool for enhancing justice rather than undermining its foundations. A particularly salient point for developing countries is the issue of bias. AI models are trained on vast datasets, and those datasets can inherently contain biases reflecting the societal norms and legal systems they represent. If an AI model is trained primarily on data from developed countries, deploying it in a developing country with a different legal system and social context could lead to unjust outcomes. Judges must be acutely aware of this risk and advocate for the development of AI models trained on local legal data. This is what I would like you to take home, unofficially and off the record of the presentation. I would like to say, I know that, well, including myself, all of us use ChatGPT, Claude, etc. in our private work, even if that is not part of a standard procedure within our judiciaries. This is very important. Please keep it in mind as you go home and start writing judgments in your next session. Everything that you use on ChatGPT or Claude or any public AI system that is not deployed in partnership with your judiciary is susceptible to that kind of bias that has been developed, of a system developed elsewhere that was not trained on legal data that comes from your country, or not legal data, period, full stop. Cross-jurisdictional collaboration is very important, despite everything that I said about localizing data. So beyond localized AI development, it is very useful for judges in developing countries to actively seek collaborations with international experts in AI and law. And there is a very simple reason for that, but I will spell it out anyway. These cross-border exchanges are necessary because the skills, knowledge, and experience in this domain, which traditionally has been very narrow, and that is the intersection of law and technology, are very few, far and in between, in the developed world, let alone in the developing world. So it works to everyone's advantage, judiciary worldwide, we are at the IAJ, to have that sort of collaboration that is coordinated by respected and respectable bodies. This cross-border exchange of knowledge and expertise can be invaluable in navigating the complexities of AI, implementation, and ensuring its alignment with local needs and legal frameworks. One issue that wasn't mentioned this morning, and it wasn't mentioned in the debate, so I would just like to put it as a placeholder for something perhaps to be considered later on, is judicial training. And I think judicial training institutes in particular in jurisdictions represented here, but also on the regional level, have an important role to play with regards to implementation of AI in judiciary, both in terms of AI that assists the administration of justice, so holding training for administrators within court registries or the court administration in general, as well as on the very important aspect that was mentioned this morning of how to handle evidence and handle and assess evidence in a world of AI, of proliferation of AI. So, as I mentioned, I'm just putting it on your radar. It's something perhaps to further consider. How can IAJ or other organizations in the space support judicial training that is sensitive to all of the issues that come up with AI? Furthermore, transparency and explainability, explainable AI. And I know I'm probably out of time already, so I will not go through to everything here, but judges should champion the development and use of explainable AI systems that provide insight into their decision-making processes. To engage with the question that came from the floor a little bit further today, so no, there are IPR, there are intellectual property issues that prevent us sometimes from being fully transparent about the AI systems deployed in our courts. On the other end of the spectrum, I have heard from judiciaries speaking about developing their own AI systems in-house. And whilst that might be a possibility for some of the developed countries with stable budgets, this is really not an option for the developing world. So I think that there needs to be further discussion, although it's a great idea to in-house that, to in-house that development, and it would definitely produce a system that is ethical, transparent, and understandable to the judges that use it. Even for developing countries, there are certain drawbacks in the sense that our judiciaries actually do not have the personnel required to actually train AI in the way that we would like to. It's just these skills are scarce and they're being used by the Amazons and Googles of the world and so on. So outside of that practical consideration, there is also increasing the digital divide between the developed and the developing world in the sense that the judiciaries in many countries cannot afford this kind of development. So again, in terms of policy and international cooperation, that is probably another point that this forum can consider taking forward. Finally, the responsible use of AI necessitates robust data security and privacy measures. Judges should be staunch advocates for the protection of sensitive personal information used on AI systems. This includes championing strict data governance protocols and advocating for the use of privacy-preserving AI techniques. Most recently, I've read some guidelines and policies coming out of Canada and the UK. On a very practical level, if you're not yourself engaged in developing these sorts of policies in your jurisdictions, in your courts, on a practical level as a judge making use of AI, please always consider whatever you post on ChatGPT or use as a document within ChatGPT or Claude becomes the property, in a way becomes public. So if you wouldn't discuss it in open court, or if your registry would not allow access to a particular file, that should not make it to any AI system that sits outside of your judiciary. And this is something that I wanted to underscore on a very practical level. And finally, I think the question about AI in our judiciaries, and I think I would have a resounding success on this, is the question is how? How do we take this forward? And I think the panel this morning and the reports that were read out this morning that were based on discussions over the past couple of days go into a lot of detail of the how. It's not a question about if, it's about how and where do you start. And as we do in my line of work, which is where we develop legal technology solution, the how always starts with small steps. Right? So it's not about having a comprehensive program that you can roll out immediately. It's about starting with small steps of implementing policies and some AI solutions into your court, testing, getting feedback, and adjusting your progress forward. And to end that how, again, on a developing country, from a developing country perspective, particularly for developing countries' perspective, do not worry that we don't have Westlaw with its AI assistance. Do not worry that we don't have VLEX with its brilliant AI assistant. We can start small now, assess and start building the skills within our judges and our legal researchers within the courts to build the skills of how to responsibly use AI and then work towards implementing some possible solutions possible low-tech in the context of AI assistance in chatbot solutions that can help us with the how of implementing AI. So thank you so much. It has been very inspirational listening to all the reports coming out of the IHA, and I certainly look forward to seeing a lot more happening on the international collaboration space from you. Thank you.
Thank you, Maria Badeva. I'd like to thank all our speakers for their brilliant presentations. It was a great opportunity to better understand how artificial intelligence impacts the job market, and in particular how AI can be used in the judiciary and what risks are involved in its use. I believe that from everything that was presented, the central idea that remains is that these new technologies can really help our work, allowing it to be more efficient, faster, and even more accurate in some fields. But their use requires detailed regulation, and in any case, the human being should not be replaced by a machine as the last word in the decision-making process. Thank you very much for your presence, your attention, and your interventions, and the conference is over. Thank you very much.
Just before closing?
Just a moment, an announcement.
We would like to give a medal to the presenters.
Of course. Okay. Well, now we still have to, the final part is to give you a medal as a recognition of your Duru, could you? No?
Try to open, it's not easy. I'm just asking if colleague Reynolds is here. This is the other presenter of this morning. Otherwise, we will have, if there's someone from Ireland, we may give him or her the medal to be presented to our colleague Reynolds from Ireland. Otherwise, we will give her later on. Thank you.
Yeah.
Now we have lunchtime, and we resume at 2 o'clock for the study commissions, yeah?
Thank you for your presentation. Thank you so much. I don't think it's realistic for judiciaries to create their own AI system. They can't even create their own. They struggle with the basics, yes. Yeah, so. There has been talk. And they spend a lot of money, it never works. So. Anyway, yeah. So you're at the University of Cape Town? I am indeed, yes. And you are in the States? Yeah, I'm federal court of appeal. Thank you. Bye-bye.
Sorry, colleagues, please don't forget that the Central Council will start this afternoon at 4 p.m. 4 p.m. the Central Council.